and the president of the H.T. Smith Bolsa, and I recognize their voices if they'd like to join us at this moment. Hello. I think, I don't know if anybody else's technology is.
I
okay.
understand, okay.
Okay, very good. All right, thanks. All right, so thank you very much. I'll keep my comments really brief, and I'm delighted to welcome the panelists. This is a really interesting and pivotal moment in history, and how we sort of think about what's happening today with the protests, the murder of George Floyd, that sort of galvanized not only a national but a global movement against racism, and highlighted issues of race, not only with respect to policing, but also sort of with respect to health issues, society, the community as a whole. So how do we see this moment within an historical context? The comparisons have been made to 1968, and the sweeping legislation that was passed yesterday by the House sort of highlights the extent to which this can be a time of enormous change within our society, transformative change within society. But obviously the downside is that it's also, the legislation that was passed yesterday has also created political divisions already. It's important to listen carefully, to learn from each other, and to sort of reflect on how we can sort of participate at this moment. And the panelists that we have today will help us understand particularly how we as lawyers can sort of engage with the community at this pivotal time. So I'm delighted to introduce, in order of speaking, Professor Michel Anglade, Professor Howard Wasserman, Professor Eric Carpenter, and Professor Phyllis Cote. And they will help us to sort of determine where we are, race protest, and the role of lawyers. So I think I'll hand over the mic to Michel. Thank you.
Thank you, Tay. Good afternoon and welcome everyone. Thank you for joining us here today. The topic of my discussion will consider the interaction of social justice movements and racial progress. I want to look at these things, particularly Tate in his opening remarks referred to the similarity of this moment to 1968, but I might even take it back a bit further. I think about the terms race and protest as frankly deeply embedded in American culture, both of those things. The country was founded on a constitution with great hope and vision and aspiration. We developed a constitution that would intended to limit the role of the effect of government on the people and to state and articulate the people's rights that were retained. I think it's important to note, though, that while that Constitution became a document that we rely on, African Americans, or would become African Americans, were slaves. They were enslaved and didn't have the protection of the Constitution. At this point, I almost want to expand the term protest to think about the idea of resistance, because protest suggests that, we are meeting together on equal playing fields in the center, in the town square, to engage in public discourse as equals. And that was not the case in the earliest times of our country. African Americans were not protected by the Constitution. They were not protected by law. African Americans in the form of slaves were not protected by law or the Constitution. But it would be a mistake to believe or even consider that there was not resistance to the institution of slavery. It was that resistance that ushered in the civil rights movement, the Civil War, and the 13th, 14th, and 15th Amendments and the Emancipation Proclamation. All of those things we point to as sort of the legal reasons for the end of slavery. But it's also true that those things were bolstered and encouraged and enforced and supported by a broad movement to end slavery. On the part of slaves, that resistance could be demonstrated through insurrections and basically leaving slavery. We hear things about the Underground Railroad, but I can't think of anything that might have been a more fitting form of resistance than creating an illegal passage to get slaves from slavery to freedom, even in the resistance of law. So there's a tension there, right? There's a tension between this our African-American history and the promises afforded and promised by the Constitution. Those promises would become closer and closer to truth for African Americans and are becoming closer and closer to truth. But on the way to the path to racial justice has certainly required protest and resistance. So I think it's, yes, the parallel to the civil rights movement, I see it, but I don't want to forget the resistance of slaves and the immediate following generations who had not been afforded yet the protections of law. Now, when we think about the civil rights movement, there's so much there. There's so much there, and it would be very difficult, I think, to summarize everything about that movement, that powerful movement. But there are some lessons to be drawn from that movement that I think relate to our present moment. There are lessons to be drawn. You know, it's often said that the best predictor of the future is history. So you need to look at that history of resistance and protest to see where it's brought us and to see what remains to be done. I can't highlight, I think we would need a class. We have a class for that, but I think we would need a class to look at the civil rights movement as closely as I'd like to. But I've been thinking about, it's hard to not watch the events of the past week and not be reminded at least of some similarities. What are those similarities? Well, first, I want to say to all of you protesters out there, and for all of you who are engaged in the work of resisting the killings of African American people by state-supported forces. The road is a long and bumpy road. The road to justice is a long and bumpy road. That's one thing we've learned from the civil rights movement. Social change, social protest is important, but social change doesn't happen like a light switch. We don't go immediately from what's wrong to what's right. The movement is more like waves, each wave bringing with it a change to the terrain and an accretion and changing the paths upon which we will walk towards justice. So one, it's not an easy walk and it's not a short walk. It's a long game. Dr. King reminded us that the arc of the moral universe is long, but it bends towards justice. We ought not be discouraged, but I think it's important to think about how far and how deep we must walk in order to get from where we are to full justice. So lesson number one, persevere and be patient because these roads are long and complex. Complicated in some ways by our very legal system and our very social structure that requires federalism, that points to federalism, and it has multiple levels of governance that relate to all of these things. So while federal law may protect civil rights on one hand, local actions relating to policing happen on a very state level. So you can't, it's not just a protest in a vacuum, right? I think another lesson that we can take from the civil rights movement is that the effective movements we've seen in American law, in American history, have been paired with other forms of resistance. So it's not just protest, but resistance guaranteed by through the rights of the Constitution. Resistance can take the form of, yes, taking it to the streets, but we know from the civil rights movement that boycotting is certainly an effective form of protest. Individual action can be an effective form of protest. And I suppose another piece of that is that we know from the civil rights movement, we know from the present movement that resistance will be met by counter resistance. In as much as there are people who want to change some of the injustices that we see, there are people who benefit from and would like to maintain the status quo. And so becomes a bigger force because resistance is met by counter resistance and the fight continues. The fight continues necessarily so. Another lesson that we can take from the civil rights movement, I think is beautifully manifest in the current protest, is the power of solidarity and the necessity of coalition building. There is no way that we could have, that a national and global movement would have been launched following the killings of Ahmaud Arbery and Breonna Taylor and George Floyd and many, many others whose names we may or may not have known. This became not just a state movement, a one-time thing, it became a national and global movement. That was due to, I think, attention raising, consciousness raising, communication, solidarity building with populations with shared concerns. So we may not always have the same concerns, but we can certainly find support through one another in fighting these fights. How am I doing on time, people? I guess I'm okay. 1 minute. I knew that was going to happen. So I'm going to wrap it up by reminding anyone who's engaged in the protest that the work is long and it's complex, and the work is multi-level. The work is in the streets. The work is on the internet. The work is in the arts. The work is in law. The work is in our conversations in our daily lives and our daily actions. The work is wherever you are. So don't think that protest only looks like one thing. Don't think that the protest will be over in some magic moment. And don't think that the end of the protest will mean that it's the end of fighting for this cause in multiple ways. I will conclude by saying one of the very important ways that African American and other people can assert and affirm their rights would be to make sure that you vote in November and in every local election that you can participate in. And that's necessary because, as I mentioned before, these problems are not just handled at the federal level, and the national attention is important, but the local action will be more important. So in addition to knowing what celebrity did what today with regard to this effort, it's important to know who your local congressperson is and who your police chief is, and how do you contact them, and how do you make your voices heard in an ongoing, sustained way. I look forward to your questions and the other panelists. Thank you.
Thank you very much. Thank you very much, Professor Anglad. And we go on to Professor Wasserman. Howard?
Thank you. Good morning, everybody. Thank you for coming. Thank you to Dean Page for organizing this, and to BALSA and the SBA for putting it together as an educational institution. The most important thing, or one of the most important things we can do, is come together and talk and teach and learn about what is going on. So what I want to talk about is the law and then the practical reality of public protest, because that has now become a significant piece of the story of the killing of Mr. Lloyd, that protests over an act of police violence and excessive force have themselves revealed police violence and excessive force, that protests over discriminatory and militarized police conduct have revealed more discriminatory and militarized police force. So let's start with the law. So these protests are occurring in what the courts refer to as the quintessential traditional public forum: streets, parks, and sidewalks. The places that time out of mind have been used for assembly, communicating with the public, and discussing public questions. And public forums are governed by, traditional public forums are governed by a set of rules that on their face are extremely speech protected. So government cannot engage in viewpoint discrimination. It cannot allow pro-police demonstrators and bar anti-police demonstrators. It cannot allow pro-Trump demonstrators and bar anti-Trump demonstrators. You have a right to record, audio and video, record and photograph police while they are conducting their business in a public space. You have to stay far enough away so that you are not disrupting, but you have a right to record. You have a right to hold on to those recordings, and I'll come back to that in a little bit. You have a right to shout really loud. You have a right to hurl insults. You have a right to cuss, and the circumstances certainly warrant it. Now, this one's a little bit dicier, actually, because it turns out that in a number of states, there are still laws on the books that prohibit the use of profanity around women and children. Now, I don't think they are validly enforceable. They certainly shouldn't be, but some police departments are actually trying to enforce those. You have a right to display signs that contain offensive, disgusting, profane slogans and images. And the police cannot allow what's called a heckler's veto. All right, so if there is someone watching the protesters and he doesn't like what they say and he tries to stop the protesters from speaking, the obligation of the police is to get that guy out of the way and to allow the protesters to continue. What the police can institute are what are called content-neutral time, place, manner restrictions. And if you all haven't taken Professor Baker's First Amendment class, make sure you do in the next couple of years. Content neutral, they apply to all speech regardless of the subject or the message that's being presented. And they are regulations on the time, place, and manner of the speech, where the speech occurs, when the speech occurs, the manner in which the speech gets presented. And those regulations are subject to intermediate scrutiny. They have to serve a substantial governmental interest, they have to be narrowly tailored, and they have to leave open ample alternative means of communication. So a time, place, manner restriction could be something like a curfew. A time, place, manner restriction is laws that prohibit looting. A time, place, manner restriction is laws that prohibit blocking traffic or blocking entrances to buildings. And the problem that we run into is that, from a First Amendment standpoint, is that courts are very receptive to content-neutral restrictions that are done in the name of serving the government interest in protecting the peace, protecting public safety, protecting national security, protecting public order. And this has been true going back to 9/11 and the protests that followed the start of the Afghanistan and Iraq wars. So police can impose free speech zones. They can say you can protest over here, but not over here. They can confine speakers or limit speakers to this area and not this area. So they closed off Lafayette Park, or Lafayette Square, excuse me. They close off Lafayette Square and direct the protesters to some other spot. You can't get up to the steps. You can't get up the steps to enter the Lincoln Memorial, although it can be down at the bottom of the steps. They can move protesters so that they're not obstructing traffic or not obstructing buildings. And ultimately, the police can decide that a crowd is too large or too unruly or just too overwhelming. And they can declare an unlawful assembly, and they can issue an order of dispersal. And then the question is how everything plays out after that order of dispersal. And so what really governs public protest is less the formal legal rules and more about negotiation between the police and the government and the protesters on how things are going to play out. How much leeway are the police officers willing to grant? Are they going to go in with a stance of, we are going to allow the maximum amount of speech, assembly, and petition? Are we going to ignore small violations? You know, if people sort of leak out off the sidewalk into the streets, are we going to ignore it? If some traffic gets snarled a little bit, are we going to ignore that? You know, is it enough to say, hey, just don't destroy stuff and let them go? Or will the police ignore sort of minimal amount of, you know, sort of minor property destruction if people start spraying graffiti or knocking over signs? And we've seen police officers join the cause. We've seen protesters giving water to police and police giving water to protesters. If we do have to issue a dispersal order, how much time and space are we going to allow? Is it, you know, announce we're going to clear things out and then give people time and space to sort of leave on their own? And the conflict that we've seen generally results from either the absence or a failure of that negotiation and that leeway, where the police come in sort of loaded for bear in anticipating confrontation and assuming a posture of confrontation, and moving very quickly to disperse large crowds. And then the violence erupts when the crowd doesn't move quite fast enough, or when the crowd is a little bit resistant to the order, when the police decide that the rowdiness or the mischief of a couple of people within the crowd becomes the basis for, rather than just getting those people out of the way, becomes the basis for shutting the entire thing down. And then the police respond with force, where they are going to forcibly, non-lethal force, but forcibly move people out of this space. And that's where the conflict arises, because there's a further sense that once some level of non-lethal force is okay, then anything goes within reason. And that's where we see non-tear gas, tear gas, rubber bullets, the sort of failings pushing protesters away. Am I out of time? 1 minute? Okay. I want to end on one point, though, which is the indispensability of video. One of the key things that's been happening here is that everything is being recorded because everybody's a photographer and everybody's a videographer. And the police know it. And everything that's happened is being captured. And so the year analogy that I might use to go back to Professor Ansa's point is not 1968, but rather 1963. And one of the narratives, or one of the stories of the civil rights movement in the 1960s, is that public attitudes outside of the South changed in response to TV cameras broadcasting images of fire hoses and police dogs being turned on public protesters. And that was all being zoomed into or broadcast into houses in the North. And that changed public attitudes. And I think we are seeing that because the attitudes that we're seeing from large segments of the public now are not, these people are out of control, the police have to do something to stop them, which is what we saw in 1968. It's, we see police who are overreacting to peaceful protesters. And the video are an essential part of that. So perhaps the revolution will not be televised, but it will be seen on Instagram. Thank you.
Thank you very much, Howard. Thank you, Professor Wasserman. I thought you were going to say about, with respect to images, the image of Emmett Till in the open casket was also a very galvanizing event back in the 1960s or 50s. So we now go to Professor Carpenter for the role of military in law enforcement. Eric?
Thank you, Tay, and thank you to everyone that's organized the event and also for showing up today and participating. So I'm going to talk about the law of using the military to perform police functions and what changes we might need to make. I'm not going to talk about another problem, which is the militarization of civil police, which is underwriting a lot of the discussion right now about defunding police departments, reshaping them in the way that Camden has done. That's a whole nother problem that we need to pick up. So I guess a week ago Monday, we actually went through a moment of constitutional crisis. And we don't often see moments like this we're seeing them more in the last 2 or 3 years, but we don't often see moments like this when the boundaries have been pushed and people are scrambling to try to find out what the answers are. A lot of what came out in the media about when the military can do police functions wasn't exactly right. So I'm hoping to clean some of that up so that everyone watching can move forward and give their input on policy changes from an informed perspective. So here's a very, very basic rule, right? Here's the answer to the exam. Federal troops cannot be used for law enforcement. Right? That's from the Posse Comitatus Act of 1878. But I think probably a lot of you are going to have an initial gut reaction, which is, I watch TV all the time. I see people in uniform all the time out there doing things after natural disasters and things like that. So let me clean some of that up. The first is that the rule prohibits federal law or federal military, right? So people acting under Title 10 of the US Code. It doesn't ban state military, which is the National Guard, operating under Title 32. So what you might see on TV often is National Guard, and the National Guard, when they're called up, can actually do law enforcement functions. It turns out that governors rarely do that. What the governor will do is put the National Guard in kind of safe spots so that they can free up the civil police forces to go into the hotter spots to actually do the law enforcement duties. So again, what you might see on television is the National Guard, and that's what we saw actually in Washington, D.C., which I'll circle back to. The second part of it is the federal military can't do law enforcement duties, right? Arrest, search and seizure, applying force to arrest and do searches and seizures. So they can't do that, but they can do lots of other stuff. And you may see on television after a national disaster, like trucks of military rolling in someplace. Well, they're doing what's called civil support. And that's different than law enforcement, right? They can distribute supplies, they fight forest fires. Federal troops can do all that because it's not law enforcement. All right, so that's a couple things to keep clear as you're watching the news and trying to figure out if you're observing a constitutional moment or constitutional crisis. Returning to the law itself, this ban came about after the federal forces occupied the South after the Civil War. It was really a movement at that time by the southern states to say, we're never going to see that again. It really wasn't an issue before occupation because historically the American military has been very, very small. Sometimes on the order of like 2,000 active forces. After that occupation, the law came into effect, but it has now become a constitutional norm. And by that, I mean, it's taken on, it is now a part of our federal government structure, right? So even though it's just a law, if we were going to try to reverse that law, I don't see how it would actually happen, particularly now that we have a large standing army or military, which I'll return to. Okay, so that's the basic rule. Federal troops can't be used for law enforcement. Here comes the comma, but, right? But rules have exceptions. If Congress has carved out an exception, then the federal military can actually do law enforcement functions, actually act as police. And that's the Insurrection Act of 1807. And that's what we heard a lot about in the news, right? And there's a bilateral component to it, which is the state can ask for federal help to put down an insurrection. You may have heard in the news that the governor might ask. Technically, it's supposed to be the legislature, and only the governor asks if the legislature can act. That's the bilateral component. We're not dealing with that right now. What's in the news is unilateral, right? When can the president of the United States order federal troops into a state, even when those troops aren't requested? And I'm going to simplify the law a little bit, but basically it's that if federal law cannot be enforced in either state or in Guam or in the Virgin Islands because of civil unrest, then the president can act unilaterally. That's a little boiled down, but it's close enough. Now, when Congress granted this power in 1807, the world looked a lot different, right? So there was no standing army to speak of. Communication and deployment times were so slow that it really wasn't granting him much of a power. Like, if you had some forces in South Carolina and there's an insurrection in Maine, good luck, right? Good luck getting forces to Maine in time to make a difference. So it wasn't a huge grant of power, and it still was that the state militias were going to take care of most issues. They were small at the time, but they were responsive. The world now is different, right? Post-World War II, we did not demilitarize. We kept a huge standing military. Response times are immediate, and the power now is huge. The real check on that, because the law hasn't changed, is that we now have large state civil police forces, and we have large state National Guards. So the idea that the Insurrection Act could ever actually be triggered now is kind of, it's not really plausible, right? Because states can always put down unrest. They have the resources. And if you watch Secretary Esper's press conference when he came out and kind of went contrary to the administration, that's what he was saying, right? Is, look, I cannot see the Insurrection Act being invoked, particularly under circumstances like this. But there's no indication that state forces cannot handle civil unrest. So we should really never see the Insurrection Act being invoked unless there's a bilateral request, which we saw after the Rodney King riots, or under very, very rare circumstances, which we actually saw in terms of unilateral action, is when the state government will not enforce federal law. And we saw that happen with after the desegregation orders, when we send in federal troops to end segregation in schools. Maybe it could come up then, but we are definitely not in those kind of circumstances. So the really easy question, or answer to the question of when should the military be involved in these kind of, in policing these kind of protests, the answer is never, right? So that's kind of a short answer. A couple of other oddities which have popped up are, well, what about Washington, D.C. and Puerto Rico? Right, they were not included in the Insurrection Act. So I think we should see some amount of reform in the Insurrection Act coming up on that. When the federal government did send some military police up from, active military police from Fort Bragg, that would have been a violation of the Insurrection Act if Trump had used those troops. He didn't, he was only using DC National Guard, but that's an issue. Another big issue is, what if there's a conflict, right? What if the state governor says, no, I don't want federal troops coming into my state? Are we gonna have a standoff at the border? Or can this be reviewed in court? And I think this is gonna be something that's picked back up. Some think these decisions are non-justiciable. I think that doctrine is kind of bogus to start with. But in the law is actually written a standard of review, which is the president can do what he considers necessary. So there's a deferential standard already built into the statute, which is something close to an abuse of discretion. So I think there could be a lawsuit filed, quickly acted on, but there's a standard of review built in, which is pretty close to worthless, which is something like abuse of discretion. And I think that's going to be something that's going to be invoked or relooked at as we reflect back on these moments and how do we limit potential power. The one bit of good news that came out of this is that posse comitatus, the norm behind that now, is so strong that even Trump thinking about it brought about a huge chorus of people you would not normally hear from. All the retired Joint Chiefs of Staff, Secretaries of Defense, lots of people coming out and saying, don't, right? You're stepping over a line that can't be stepped over. And Trump backed off. Lots of constitutional norms have been run over recently. That one was, there was enough strength pushing back that it was stopped. And one of the things that had, my last point, one of the things that hasn't come up really when they were coming back is the threat to our national security if Trump had politicized the military against the Black Lives Movement, right? 30 to 40% of our active forces in our Guard are people of color, right? So if you politicize that, good luck recruiting, right? Good luck filling out a military that can satisfy, we have national security threats. If you lose that population, good luck. And that's also some of what was underwriting that fight back was post-Vietnam, our military was in terrible racial shape. It's pretty good now. And we can't risk that, right? It's a threat to our national security to have a military that is polarized on racial topics. So thanks for having me.
Thank you very much, Eric. Thank you. That was brilliant. I should mention that please, audience, welcome, and feel free to submit your questions on the chat vehicle as we proceed. We're going to listen now to Professor Cote, who will speak on the role of lawyers. Phyllis?
Great. First, I'd like to thank Dean Page for envisioning the need for today's program and for creating a forum for this discussion of race, protest, and the role of lawyers. And I especially want to applaud our Black Law Students Association and the Student Bar Association for being a part of this program, because I think by their participation and by the participation and attendance of students, we're really exemplifying our commitment as true leaders and agents of change in the 21st century. Now, while no one could have predicted the specific incident that led to our present racial unrest and social protests, it should be no surprise that the historical tightening of the noose of racism and pressing of the knees on the necks of the oppressed would have led to such a united moment as this, where those of us who care about justice are called upon to speak. As we examine the role of lawyers in today's political and social climate of racial unrest and social protest, I think of the saying from Shakespeare, and it's actually Henry VI saying, the first thing we do, let's kill all the lawyers. And I say this not as a criticism that lawyers maintain a place or privilege of power and wealth, and we do, but with great power comes great responsibility. And a vital role of lawyers is to meet their responsibility in this time of racial unrest and social protest. The legal profession can open powerful social, financial, and political avenues to generate social change. You know, I also, when I think about the first thing we do is kill the lawyers, I'm not necessarily acquiescing to this perversion of the law that can and has been used as a club to brutally beat the heads of those that disagree and confront the status quo. But this role of lawyers is especially fitting in a time such as this, as we confront racial unrest and social protest. However, ultimately, when I think about this statement and I think about the first thing we do, let's kill all the lawyers, I find it really indicative of the implicit praise of how lawyers stand in the way of the violent mob. Lawyers have a history of standing in the way of the violent mob in this country during critical times of social upheaval, and today is really no different. It is the role of lawyers standing in the way of the violent mob that epitomizes and characterizes this discussion of race, of racial unrest, and social protest. We really must frame our understanding of the role and responsibility of lawyers as both professionals and citizens of the 21st century that are ready and able to act in this midst of racial unrest and social protest. And specifically, it is to this vein that I seek to give content to basically 4 ethical responsibilities or duties that are utmost importance as we think about what lawyers do and how they do it. And these are, first of all, the duty of lawyers to their client and stakeholders. Second, the duty of lawyers to the legal system. Third, the duty of lawyers to the institution. And finally, the duty of lawyers to society at large. A fundamental point for today's discussion is consideration of these ethical dimensions of lawyering. And in this era, we must give equal attention to those ethical considerations as we deal with this atmosphere of racial unrest and social protest. What does this mean? This means that the role of lawyers must be highlighted and integrated with the significant racial, social, cultural, and of course, political changes that are affecting our legal institutions and the people and institutions that lawyers serve. The duty of lawyers to clients and stakeholders is clearly born out of this definition that we use for social lawyering. It focuses on the lawyer's ability to fight the status quo and to provide redress and representation to the voiceless. This definition provides a role for lawyers that raises the ante by focusing on the specific task of addressing unrest and defending protests. For those who enter the legal profession as a means of ensuring fair and zealous representation to those under attack, what a fitting role this definition provides for fighting for protesters. Lawyers have an obligation to work for the betterment of the legal system and have a unique role as guardians of the law. The arrest of protesters and the action of groups organizing protesters have provided an opportunity for lawyers to serve clients and their stakeholders. Another definition of political or social lawyering refers to lawyers whose work is directed at altering some aspect of the social, economic, or political status quo, and who believe that the current societal conditions obstruct the full participation of and sufficient benefits to subordinated people. As tireless champions of the accused, public defenders work with the belief that current societal conditions obstruct the full participation of and sufficient benefits afforded to subordinate people. Public defenders are the lifeblood of the criminal justice system, working on the front lines as warriors. They see the result of systematic abuses like racism and bias in our legal system. And with the addition of countless others by the arrest of protesters, it is now the role of lawyers to help fill this gap. Professor Cornel West suggests that the impact of progressive lawyers come from a combination of defensive work against cultural conservatism, radical legal practice through academic critiques of liberal paradigms, and participation in extra-parliamentary social movements. The role of lawyers in their pursuit of duties in various institutions ignite progressive change. Lawyers have a role of curing historical amnesia, ensuring that the preservation of past struggles and building on the traces and residues of past conflicts. By using previous conflicts to provide a framework for their endeavors, lawyers for social change can build on previously earned political ground. It is on the shoulders of previous conflict and those conflicts for equality that we stand today. The role of the lawyer as monitors of our institutions is key. Finally, a duty to society at large emerges from the advocacy that consciously strives to alter structural and societal impediments, the equality and decency as the works of lawyers to provide representation to individuals, groups, and interests that have historically been unrepresented or underrepresented in our legal system, and who are fighting for established power or established distribution of wealth. This is where we end in our examination of the role of lawyers, especially during this time of racial unrest and social protest. It is no longer a question of whether we fit in the struggle, since even our silence registers decibels as a position in this debate. The real question is to begin to try to figure out where and how we fit in as lawyers. Thank you.
Thank you so much, Phyllis. Professor Cote, that was really well placed. So thank you all. We have some questions from the audience. I have some questions for the panelists as well. I see questions coming in. Let me sort of begin with a couple of questions I have, and then we'll sort of review the questions coming in. So the first question I had as I was listening to Professor Anglade was, you know, sort of in in her discussion of race, protest, and resistance, she sort of talked about the extent to which the federal government is resorted to for, for assistance, for redress, for reform. But, you know, as we've looked at the history, the federal government has also been responsible for the problems that we have. So I wondered if she could speak perhaps to reconciling that sort of yin and yang or pro and con of the need for the federal government, the attenuation of its importance through 40 years of various attempts to reduce the size of government for various governments, and how it's really, especially in the COVID era, highlighted the extent to which the federal government is desperately needed. To Howard, I had a question about the boundaries that he just talked about in terms of the negotiation, where the law only takes you so far with respect to protest, and then the rest is negotiation. Can those lines be redrawn? Can we rethink the lines of negotiation, given that so much of what has happened has impacted a certain population more than other populations? And I think, for example, of sort of the protest on the steps of the Michigan State building, where the negotiation, you could say, was given enormous, wide berth in terms of allowing a group of people armed to sort of be left alone, but protesters peacefully protesting in Lafayette were pushed aside. Third, a quick question to Eric. I was wondering, as he was speaking, about the pushback against the president's sort of reflections on Posse Comitatus. And my question, I suppose, and this is one thing that's in the debates, is that kind of pushback going to be enough as we get closer to November and this administration becomes more desperate to retain power? And to Phyllis, I was very grateful for the kill all the lawyers quotation. And I'm wondering, in terms of the four duties, where she thinks that sort of, if you like, the sort of negative, that what she did in her talk was to reflect all the reasons why laws are actually really critical, but that sort of negative retention in the popular imagination of lawyers, where in the four duties does she see that most implicated, and how does that impact the current situation today? So those are four questions. You're free to answer them, and then we'll sort of go through the other questions too. And by the way, I should mention to everyone attending that even though this is slated to go till 1 o'clock, we are going to go much longer if you feel compelled.
Okay, thank you for that, Tay, and thanks for the questions that are coming in. I look forward to these discussions. Tay, you asked a question about the federal government, and I think it has to be looked at as sort of an ebb and flow. The pursuit of rights is seen as an ebb and flow. So the federal government is doing a few different things. It's, yes, protecting constitutional principles, but also balancing the interests of federal government and those of the states. I think, we have a well thought out document that intends to balance checks, to balance powers among the states and the federal government, and also among the different branches of government, the legislative and the judicial bodies. It works best, I think, when people are participatory in democracy, and it works best when the systems are allowed to, are able to, in fact, check and balance each other. So I think we're in a time where that's not happening as effectively as the drafters might have preferred. But I think it's important as well to remember that the actions taken have to resonate on those different levels, not just a federal and not just a state level. Probably with regard to policing, most of the change that one would want to see, or most of the accountability that we might address the attention of the moment to, will be at a state level. And what the states can do, the extent to which the states can engage in conduct that seems abusive to citizens, is where the federal government might step in and say, well, you know what, you are now in violation of that constitutional amendment which promised equal guarantees and protection of law. So it's the federal government, through the Constitution and legislation, is able to cabin, I don't want to say limit, but perhaps limit is a more accurate term, state conduct, but states also have latitude with regard to particular things, and relevantly here, policing.
Thanks. I can go on to other questions, or the panelists can address some of the comments that I made.
Well, in response to what you asked me, I mean, I think even as I thought about where lawyers fit, and there's certainly different places, it really is that implicit role of protecting the violent mob, protecting the unpopular opinion, the unpopular decision, protect who is under attack, and being there, and actually on both sides, having the lawyer there for the attacker and the one being attacked, but protecting the rights of everyone and ensuring that it happens. And I think regardless of your political stance, there's a place for everyone in terms of what they can do. But I think what we're finding, especially right now, is that some things just defy logic. I mean, we talked about video and having video. There was video of Rodney King. There was video of during the 60s, but the expansiveness of the video and the ability to see it on live feed and to know, usually there's always an undercurrent. I mean, so even as a prosecutor and as a judge, there was always the defendant acting in a way that required me to, and say it would be something else. You didn't see it all. You didn't hear it all. But I think this time we were all able to sit and watch from beginning to end. So even when you wanted to say, but that's not everything, but we didn't see everything, but there is more, we had the total video. Even of the 70-year-old who tripped, and then we find was not tripped at all.
Okay, I'll go ahead and answer your question to me also, which is basically, Trump backed down this time. What happens if he comes under more pressure and doesn't back down next time? And that's the way constitutional crises work, right? Which is one side has to back down because sometimes there's a clear answer in the Constitution, but sometimes there's not. He backed down this time, and I think there's two important points about that. One is that Esper's press conference was really him putting out in public that this is a line in the sand, right? I'm not going to order federal troops into any states as long as he's the Secretary of Defense, which can always be fired. But the other thing that's important about our military is every officer takes an oath to the Constitution, right? So they take an oath to the rule of law as opposed to an oath to a person. And they take that seriously. And that came up in the discourse over the last week. And everything I've talked about up to this point is national security law. If you're interested in that as a student, look for that to be look for that class when it pops up. What I'm about to talk about is military justice. So if this is interesting to you, take that class. But you're not allowed to follow unlawful orders. So if Trump tells somebody to violate posse comitatus, the person receiving that order has the obligation to say, I'm not going to follow that order. And oh, by the way, they can't be put on trial later for not following that order. So that's where we would go next. And I think what's been unfortunate up to this point is the only constitutional pushback has come from retired people in the military, retired secretaries of defense. And we haven't heard pushback from the Republican Senate. We would have to see if there would be more coming up in that moment as the Secretary of Defense quit, as the Chairman of the Joint Chiefs of Staff quit, or if they started to refuse orders, what would happen in a moment like that?
So there were people with phones and cameras in Ferguson 6 years ago. Why the response? And that just gets into a lot of broader societal, of social movements and social change. Why was the mass movement for integration in the early 60s rather than 5 or 6 years earlier, immediately after Brown or immediately after, for example, the Montgomery bus boycott? Why this and not Ferguson? I think part of this is the fact that the precipitating event was captured on video. where we didn't have that with Michael Brown in Ferguson. And part of it is, I don't think you can avoid the broader point of what's going on in society. This has become as much about this particular police killing and police violence generally than it is about this presidential administration. And there's a connection between those two things that there wasn't back in Ferguson. So I think the question of why now is something, particularly if we see real change come out of this, is I think something that's going to be a source of study and a source of interest for this time period.
Great.
And let's get on to some of the audience questions.
Yes. So I'll share 3 questions and then we'll sort of respond to those, and then 3 more if that works for you guys, because they're coming in now. So the first question has to do with the constitutionality of the curfew, and the question involves what seems to be a kind of arbitrary nature to curfews. And as he puts it, or she puts it, I understand the reasoning of the court, but perhaps that reasoning was removed from a reality where curfews are imposed with short notice and shifted often to criminalize peaceful protest. The second question has to do with the question of benefits. Do you think that people who tend to benefit from the status quo would be willing to change it? Statistics show that 85% of lawyers identify as Caucasian, and African Americans are incarcerated in state prisons across the country at more than 5 times the rate of Caucasians. The third question has to do with the policy of, let me try and read this. It says, maybe this speaks more to policy and legislation, but how can something like a cash bail system be changed, even incrementally in the near future, in order for it to have a meaningful impact, even on the lives of the people who are currently out on the streets now? So I wonder if the panelists could address 1, 2, or all of them. Yes, Michelle.
I will take a stab at a couple of them. With regard to curfews, yes, Brandon, I appreciate the question. I don't know that I would interpret that, the current sort of changes in curfews and the change time and the short notice, as quite unconstitutional yet. But I do think it raises a question about what's the limitations that the states and local governments are putting on protesters. There is, remember, because policing happens at a state and local level, there's latitude in the various interests in our society, not just the right to protest, but also keeping the peace and things like that. That's sort of, that's the answer that might be given. But there's also, I think, a show of force that's happening that's part of the resistance and counter-resistance that we see to these movements. So yes, you do have a freedom to peacefully protest, but at a certain time, we're going to say you being in the street may not look peaceful enough to keep our streets safe. And it's a balance, but I think you're right to be attentive and mindful to it. I also think, because we've been caught up in COVID for 3 months and in the trappings of COVID and stay-at-home orders, that it's almost a perfect storm. It's almost a perfect storm of questioning how much authority do we allow. How much do we allow the state to limit people's movement and how they are in the world, and whether or not to wear a mask, and whether or not to have stay-at-home orders? These are all issues. Recall that the federal government couldn't enforce a stay-at-home order. That had to be done at the state level. So now, on the other hand, we saw nationally that states had different reactions to those stay-at-home orders. So I think the impulse to question the limitation on freedom is the right one. On the other hand, I think that the curfews as we've currently seen are probably within the proper range of governmental authority. The 2 other questions. Oh, I'll hit the bail one first, and then I'll go to the benefits and the status quo. The bail thing, that's one of those longer term changes, I believe. So we have to think about what are the effects of protest? What do we want to get out of this protest? What's going to happen out of this protest? That should be bail reform. The cash bail system should be one of the things that we look at in a longer term view to limit the wrongful incarceration of anyone, of any number of people. We should certainly examine that. In the interim, what needs to be done? I would suggest that the answer to that is not within the law, because that's not going to happen fast enough to serve the interest and the urgency of being arrested. So I think on that level, that's about the grassroots approach to making sure that those bail funds are well funded, making sure that if you are supporting the protesters but can't be at the protest, and among the things you can do is donate to the legal services and the legal aid bureaus and the bail services that are helping people to continue to resist. And status quo and benefits, man, that's not an easy question, because the benefits aren't equally allocated, and I don't know that the benefits or harms of the status quo are always neatly drawn along racial lines. I think there are other factors that influence who benefits from the status quo. But it does underscore what I think is the need to continue building coalitions and working in solidarity, so that we recognize that some of these harms aren't just harms for African Americans, they are harms for all Americans. And through that vision and that expanded vision of what's happening, I think we start to think about or question whether that status quo really does benefit everyone.
Thank you, Michelle. I'll pose the next three questions. So the first one is, how can young attorneys who might not have a lot of decision-making power in their firms, corporations, state agencies, public defenders, and state attorneys, successfully advocate to a more inclusive legal system? Sometimes it feels we are bound by the institution, agency's policies. This is a question specifically for Judge Cote. How can prosecutors advocate towards non-convictions in terms of recommending mental health help or substance abuse help when working in a setup where superiors might not allow you to refuse issuing indictments or information? And I'll just ask the third question. This comment suggests that another factor that led to such an immense movement is the timing. COVID-19 led to an increase of unemployment, and it is the summertime. That being said, I believe it is important to realize how big of an issue capitalism is as another systemic problem. So those are three for the panels, one specifically for Professor Cote. Maybe another panelist would like to address one, two, or all of them.
So, I mean, I'll start out in terms of looking at, I think, a couple of them that really talk about the role of lawyers and the limiting nature of being a prosecutor or a new lawyer or a new public defender. So what I want to suggest is that's why externships and internships become so important, because you find that you have a lot more latitude than you think. While ultimately, yes, you work for a supervising attorney that must approve your dropping of charges, the offices realize that we are overcrowded in terms of prosecutions. And there's a level of hierarchy that's given in terms of how crimes are treated. Mental health courts, especially mental health court around the country, but that have become quite famous in Broward and Miami-Dade, that look at attempting not to incarcerate those that may be dealing with other issues. We have veterans courts, homelessness courts. So I think a lot of times when you're on the outside looking in, you aren't aware of the availability of resources. I think it's key in terms of your role as a new lawyer, and certainly your role as a law student now, is to try to figure out how the law affects those without money. And what is it that you can do within the role of your actions as a lawyer to enhance kind of justice and equal play.
Howard, Eric, you want to pick up the other two?
You know, I'll just kind of tie one of these questions back to the earlier question, and the earlier question about the relative makeup of the legal profession or the relative makeup of police forces, and how you bring about change. And one of the things that we see is that the incentives are built in to the institution, regardless of how you, regardless of the background you bring into it. So there's no difference in use of force by female officers, by police officers who are persons of color. There's not necessarily a difference. I think this has been less studied, of how female prosecutors or prosecutors of color pursue certain cases. There are internal sanctions that are greater, but the external incentives, remain. I think it is probably the case that institutional change can't come, and I think both questions may illustrate this point, that institutional change can't come from one group only, because there are people who are more senior who have the power structure, and somehow when you come in new, you've got to convince the powers that be to change that structure. I don't think the people in power can do it themselves. I don't think the people entering the profession or entering the structure can change it. I think it has to come from both.
Okay. So I'll go straight to the next three questions. I think these may be the last. So one question is, what can we do as a community? How do we get started? Can we get a working group together? The second one is a lawyer or a law student who acts as a legal observer at a protest bound by the rules of professional responsibility whilst acting in that role? Anyone to address these? Actually, there is one question that is addressed to Professor Wasserman, but it pertains again to the videos and the broadcasting of them. And I think it implicates the rules of evidence. Panelists?
What was the question?
So the question is the importance of videos. How do new...
Oh, I found it. So apparently Tucson has enacted an ordinance prohibiting photographing or recording law enforcement. I had not heard about that. That's not long for this world. That's the easiest answer for that. That law is not going to be around and enforceable for too much longer. I don't think the Ninth Circuit spoke to it, but at this point, every court to address the problem has said, yeah, you have a First Amendment right to record the police. And unless you are genuinely interfering, they can't do anything to stop you.
Okay.
I want to say one more thing about cameras and the use of cameras. You know, I think the thing that's making this moment remarkable is the many people who are recording, and the people who are willing to give over recordings if they are not actively recording, but they might be a business or something that has a camera. So yeah, there's going to be resistance. There's going to be pushback to that resistance. If cameras and filming and footage and publication of these things will advance the cause, there's going to be a resistance to try to back up all of the possibility of those things happening. But it's hard to question, and it's hard to limit the public in such a manner. And there's nothing illegal about recording, and there are certainly different ways to record. So you very much think about the First Amendments with the right of reporters and media And social media, yes, there may be professional limitations, but individuals are still free. And I would say that to the young lawyers too. Young lawyers do not give up their constitutional rights. You may need to be careful and manage the kind of engagement that you partake in, but there are certainly many ways to amplify the voices of dissent without engaging in matters that might threaten your professional well-being or personal well-being for that matter. Others? Sorry, didn't mean to jump in there.
So to the question of creating
what can you do? A working group?
What measure can be created to police law enforcement who use private firms for data collection in order to make sure their data is used correctly and are transparent in how it is used? That was a question that came through. Any thoughts on that?
I don't know that we're going to get efforts that encourage transparency at this point. I suppose we would likely get efforts that are responsive to the misuse of data in the first place. So the fact of collecting data, as much as that might make people uncomfortable, does not raise an objectionable constitutional concern that I can think of. Maybe others can pipe in if I'm wrong about that. But how that data is used may then become an issue. And it's not only government, right? It's also who it is that's collecting your data, who you're giving your data to in many instances in terms of your cell phone usage and things like that. It's a bigger question than I think this panel can take on, but there are certainly measures that can be taken, and again, probably a longer term view of things.
I want to the question that Professor Cleon asked about a lawyer or law student acting as a legal observer. I mean, I don't know the answer to that. On the one hand, I think you're a lawyer whenever you do something, and so that so that is going to come into play. I know there were 2 lawyers in New York who threw Molotov cocktails and were arrested, and when they got bail, the Court of Appeals reversed the decision to give them bail, and partly came down on them because they are lawyers, and because they were supposed to be held by, even in acting in this quote unquote non-lawyerly capacity, they should have been held to a higher standard. I don't know I don't know what the rules are if you are there and identifying yourself as a legal observer, if you somehow take on some obligation toward a client or not. If you have a client and what that obligation is, or if you're just a legal observer, just means you're an observer who has legal training, and therefore you're going to get in more trouble if you throw a Molotov cocktail.
I think it's important too here to think about
being there as a legal observer that got them in trouble, but the oath they take as attorneys. I mean, committing a crime by a lawyer when they are presented before a judge increases the ante in terms of both their bail and the supervision that they may be forced to succumb to as a result. And certainly, for an attorney-client relationship to exist, I have to do something to indicate that certainly I'm your lawyer, and then you indicate something to say you want me to represent you. And while certainly that can be implicit, nothing about the participation as a legal observer in and of itself would necessarily create that. I know that I've participated in the past as a legal observer, and generally it's the role of really offering advice as to observations or taking notes in terms of what's happening, so that heightened level of creating an attorney-client relationship doesn't really take place. But you are able to testify and give information about it.
Lawyers and many others would be well served to remember that in addition to their obligations, there's a court of public opinion. So Howard, as you were speaking about the New York attorneys who were throwing Molotov cocktails, I was reminding of a New York attorney a few years ago who engaged in a racial tirade that was recorded and publicized and all over social media. I don't know that there was a way to reprimand him professionally speaking, but the court of public opinion surely did have a response. And I fired him for him to continue practicing in the same way. I know he lost a lot of clients and people withdrew, and we're seeing the same thing here. That it's not about permission necessarily; it's about your capacity and right to engage in certain actions.
I mean, the court has recently handed down rules that implicit bias and incidences of bias by attorneys are actionable in terms of discipline. So I know it's going to, it's a difficult disciplinary action to support, but they certainly are bringing them now, and we're seeing them more and more. They're being brought up against judges and lawyers of acting with racial animus, and that being indicated by words that they use and actions that they portray. All
right. Well, I think we have we've come to the end of this is a really, really interesting discussion. Thank you all so much for participating. Thank you for your very interesting questions. I see one here about a constitutional new amendment to sort of address gaps in procedural law. I'm sorry we didn't quite get to that as we're running out of time. Thank you, professors. I also want to say thank you to H.T. Smith. I want to say thank you to the president of the SBA, Constance Lee, and to say thanks also to Elisa, my former student. Hello. And
she's the new SBA president. Elisa Diaz is the new SBA president.
And she's the new SBA president, right.
Yeah, and Constance is the outgoing, and Chiani was BALSA president, is the incoming BALSA president.
Oh, lovely.
With Raquan being the outgoing.
Okay, well, thank you all. This has been a really interesting discussion. And of course, as many of you have noted, it's just the beginning. So I urge you all to come to the next two panels, and I'll leave the closing remarks to the Dean, if he's still here. Hello, Dean. Does the Dean want to make a comment?
I'd like to. Can anyone hear me?
Yeah, we can hear you.
Oh, wonderful. I guess my camera has disappeared. Well, I found that very interesting. I always learn a lot from my colleagues, and there were some wonderful thought-provoking ideas. Thank you very much if you're tuning in from outside. And I want to remind you that we will have at least 2 more panels, and there's been a lot of interest. I expect we will have additional panels coming in July. I should also add that at the law school, we are not just going to have panels in response to this. We are discussing a number of different initiatives and programmatic changes, and we are planning some intentional and deliberate changes in response. So thank you all, and I hope to see you again soon.
All right. Thank you very much.
Thank you.
Bye, everyone. Mark wants to say